Hello, everybody. Welcome. My name is Lee Schwartz, and I'd like to welcome you to our webinar. Today's topic is estate planning basics: when, why, and how. Now, we'll jump in here in just a sec, but a couple of quick housekeeping items. If you have a question during the webinar, open up the chat box in Zoom and submit your question to all panelists. We are going to try to leave a few minutes at the end for some Q&A. We're also going to incorporate some polling questions into our presentation today, so we can better understand where you're all at in the trust and estate planning process. We are also recording this webinar. You'll receive an email with a link to a survey, as well as our SVA resource page where the webinar recording will be available. Now, many of you are already clients of SVA, and we'd encourage you to reach out to your SVA contact if you have questions coming out of this. I'd also encourage you to share our contact details with other people who could use our help. Now, if you're not a client and have questions, please reach out to me and I'll get you connected to a subject matter expert who can get your questions answered. Our presenters today are Rick Kollauf and E.G. Schramka, both principals with SVA Certified Public Accountants. As you can see, they each have a ton of credentials behind their names, so I'm not going to go through all those, but they are here to help guide you in the estate planning process and answer any questions you may have. We've got a lot of content to go through. So without further ado, I'm going to hand it off to Rick. Rick, you go ahead.
Thanks, Lee. So we're going to start off today with our first polling question, just to get a gauge on the audience. I'd like you to answer in the poll as it just popped up, do you have an estate plan? Yes or no? And if you could do that briefly, that'll help us move forward. I'm told we should be seeing polling results, or I should be able to report them. So, well, interesting audience. I got 50% of the audience reporting yes, they do have an estate plan, and 50% no. So for those of you that don't have an estate plan, this is very pertinent. And even for those of you that do, you should always be thinking about when it's important to update your estate plan. And we'll see some of those milestones and when it might be important and how it is important. All right. So next slide, why are you here today, actually? And really, everyone has an estate plan. And every estate requires planning, but yet there's probably different planning that happens at different points in our lives. It's important that you should have a plan and that it be in writing. And you really want to make sure that your assets that you've worked very hard to accumulate during your lifetime go to the people that you care about or that you want them to. Estate planning, really, it can be simple, but it can also be a complex process. And you should be able to make it easier using capable and experienced professionals such as us at SVA. What is an estate? Okay. An estate includes everything you own. There's a brief list here of types of categories. Includes things as investments like individual stocks and bonds or mutual funds, retirement accounts, it's your home, it's real estate, it's business interests, it's personal property, it's intangible assets. And if you don't know what a digital asset is, it includes those in any event. So you may not think of these assets or even think of things like life insurance. Life insurance isn't something you put on a balance sheet or a net worth statement, but when calculating what your gross estate is, the IRS says that the death benefit in many circumstances includes life insurance, and that could be impactful when determining if your estate is subject to an estate tax or not, or could be. It can also include part interest in joint accounts that you own with a spouse or someone else. So then, if we know what an estate is, what is estate planning? It's really the process of outlining, as I mentioned in advance, the people or organizations that you want to receive your estate and how those assets might be managed when they're received or as they're received. It's also your opportunity to put together your wishes for how your minor children might be taken care of. I put on here, don't forget Fido. I laugh a little bit because look, our pets are really important to us, but significantly, if you want to care for them after your death, there is a way to plan for your pets, and that's something you should be doing. Then why is an estate plan important, or why is planning important? Because we want to make sure that we provide for those that we love after our death. We want to make sure that our charitable interests are taken care of, that our estate is distributed according to our wishes. Even before we die, estate planning incorporates asset protection. We want to make sure that not only during our life, but for future generations, our estate can be protected to the extent it can be. If we're a business owner, we want to make sure that that transition is handed off in a seamless manner. We want to make sure that we minimize taxes. No one should pay more taxes than they're required to, as well as hopefully avoiding probate so that we can avoid costs, not necessarily just taxes, but the costs of probate and the legal costs that may be associated with that. Again, we want to make sure that even before we pass, if there is incapacity, that there are those that we've set out that can help make decisions for us, whether that be financially or for medical purposes. So what are these stages in life that I referred to earlier, and how might that be important in how we do estate planning? So if you're young, let's say you're over 18, you want to make sure that if something happens to you and you can't make decisions on your own, that you have a durable, and I also call that a financial power of attorney, and a medical power of attorney. Oftentimes I'll consult with families as their children go off to college, and for those that are over 18, I ask them, do they have a durable or medical power of attorney? And most oftentimes they don't. It's one of the first estate planning documents that will get drafted or help get drafted for those young children going off to college, because think of it this way. Something happens while they're away at school and you get a call from the hospital and unfortunately there was an accident. Well, you're their parent, you want to help direct their medical care, but unless they have a medical power of attorney, you may not be able to have that and be involved in that decision-making process because they're 18, and the laws typically say that the hospitals to take direction from those under their medical power of attorney. Not that you won't be able to in the end, but you don't want to have those hiccups. So having the proper documents in place are important. If you're young and single, you may not have a lot of stuff, but perhaps you want your stuff to go to those who you want it to, and having that plan in place is going to allow that to happen rather than the laws of intestacy. If you're now married, or excuse me, if you're a couple but yet not yet married, you may own things together. Now, you may not be prepared to make the leap that all of your possessions go to that person who's your significant other, but for the things that you own together, perhaps you want to own them as joint tenants or with rights of survivorship, which then allows at death that asset go to that surviving person who you own it with. That's a plan. Being a married couple, now that you're married, now maybe you do wish that all of that you own go to that next person, and it should be done through some type of will or trust planning. Now along comes a child. It's really important that you set out who your guardian should be for those minor children, because if you don't, it's going to be up to a court, and you may not want the court to make that happen. Moving on, these benchmarks in life, now you've accumulated some wealth. Perhaps you're even subject or could be subject to an estate tax in the future. You need to get with that team of advisors that I alluded to and really perhaps put together some more sophistication to your estate planning that will help eliminate or at least avoid some of that estate tax to the extent permissible. Now you may be looking forward to retirement. Oftentimes retirement and later estate planning go hand in hand. There are things like retirement accounts that you should have been building along the way, and now you're thinking about using these assets to help you in retirement support your lifestyle, because Social Security may in fact not, right? So things like a retirement account or an IRA usually pass by beneficiary designation. That beneficiary designation form is important to have completed, just as it's important to have the will or trust done. That's part of your estate planning documentation. Now, we're coming up on the second question in our polling process. Is your estate plan in writing? So especially for those of you who answered, you have an estate plan, do you have all the important documents in writing, which would include, and E.G. will get into a little bit more of this, things like a will, a trust, a durable power of attorney, and medical power of attorney. Okay, so 57% of you, presumably more of you that already have an estate plan, it's in writing, and some don't have something in writing. And there's probably some duplicity here between this polling question and the next. But a lot of times I will talk with people and they will say that they have a plan, yeah, but it's not in writing. I mean, they plan that all of their assets go to their children or to their surviving spouse, but by not putting it in writing, the laws of intestacy may take control. All right, so now that we know that we need a plan, we know what our estate is, how do we go about putting together that plan, right? The first thing you should do is assemble that team. And as part of assembling that team, you want to consider what your goals and objectives are. These are some things that you should start thinking about. Are you concerned with whether your heirs have the ability to manage the assets after they inherit them? Does anybody in your family that will inherit have any special needs? Who are you going to leave your assets to? Are there specific assets you'd like to give to specific individuals? Things and questions like this are things you really need to have pondered before sitting down with the team members that are going to help draft your plan, because these are going to be questions that are going to have to be answered so that the provisions that are made part of the documents answer these questions so that your goals are then taken care of. You're going to also review any current estate planning documents that you already have. For those of you that answered yes to the first polling question, if you're going to be in the process of updating your documents, you need to gather those up so that we can update those documents and make sure that the wishes that are already in play are being incorporated as well. Now, once you've done those two things, you should be evaluating your assets, getting your hands around all of those assets. So in addition, you want to think to the future. So do you expect significant change in your assets? So as an inheritance, for example, you may have a net worth or a gross estate of X dollars today, but maybe in a few years, your parents may pass, and hopefully you've talked to them about what their estate plan is. You need to incorporate those assets that might come into your plan at a later date. You also may have interests in trusts. Some trusts could be part of your gross estate, and planning needs to perhaps happen for that as well. There are also some things you should be considering surrounding taxes. And really there's three types of taxes. There's a gift tax, there's an estate tax, and there's what's called a generation skipping transfer tax. These are separate and distinct, yet at least as of today, they all incorporate one lifetime exemption amount, which is $11.7 million per person. For a married couple, that's 23.4. Currently, Congress is in the budget process, and part of the House Ways and Means Committee drafting of the current budget, there's some indication that they're going to reduce that lifetime exemption number to $5 million in the 2017 dollar terms. So inflated for inflation for an effective date of January 1st of 22, that might equate to approximately $6 million. So you may not have a taxable estate today at 11.7, but you may in a month or so, in several months or so, at $6 million level. Multiply that by 2 if you're a married couple. So if you are facing an estate tax or the potential for an estate tax, now is the time to start planning, because some of the maneuvers that we as professionals have been counseling folks about with estate planning may be out the window, and we'll touch on a couple of those as well. But just the fact that your lifetime exemption might go down may take you out of an estate tax paradigm right into an estate tax paradigm. So how might we then move forward after we've thought about those two things? Well, we really want to start to develop strategies to make changes to get out of the way of that potential estate tax. We may think about things as gifting. We may think about things of types of gifts like tuition or medical expenses for our children or loved ones. We may think about our charities. All these things that involve gifting remove these assets from your estate and can lower what might be a taxable estate to less than a taxable estate. To the extent you use the lifetime gifting exemption during your life, that will lower the amount you have left at death. But even that isn't bad, because at least you're removing future appreciation of assets you are giving today out of your estate, which would happen at a later point. We also want to build in flexibility, right? And so to the extent that we need that flexibility, working with the estate planning council that you're bringing to the table, you're going to help bring your wishes and goals in a flexible manner. Let's talk a little bit before we get over to E.G., some other blanks that an attorney is going to ask you to incorporate. There are roles that you're going to need to identify in your documents, in the wills, trusts, in powers of attorney that I mentioned, that are fiduciary in nature. So personal representative, you may have heard of, trustee, guardian, agent. These are all duties and roles that you're going to have to fill. And as part of the planning process, these are fill in the blank items that you're going to want to have ready, so that when you go to the attorney and they ask you these questions, you're going to be able to enumerate who these folks might be. So let's turn it over to E.G. for a bit and talk about those essential documents.
Thank you, Rick. So 60% of Americans do not have a will. So when you die without a will, basically the court is going to supervise the administration of your estate, and then the state statutes are going to determine who should get your property. So to avoid that, you want to have a will. As Rick mentioned, in the will, you will name a personal representative who will basically administer your estate. And you always want to name not only a primary one, but a successor in the event that the primary one dies or becomes incapacitated. In the will also, you'll be able to name a guardian for any minor children. And once again, you should name a primary and then also a successor. And you can also have in your will a memorandum where if you have some type of collectibles or other valuable personal property that you want to go to specific individuals, you can then name that in this separate memorandum. So a will help you to basically avoid any issues with who's going to administer your estate and who will get your assets. Now, a will only does not control property that goes by a beneficiary designation. As Rick mentioned earlier, there's life insurance, retirement plans, annuities. The beneficiary designation controls. So where your will and your beneficiary designations are inconsistent, the beneficiary designation is going to control. So you've got to check to make sure that those are consistent, and also that you've named both a primary and a contingent beneficiary for these types of assets. Now, if you want to avoid the cost of probate and the additional time that it would take to administer your estate, you can always title your assets in a revocable trust. And since Wisconsin's a community property state, you can have a joint revocable trust. Now, titling your assets in a revocable trust is not going to save you any estate taxes, nor is it going to affect how you deal with your assets during your lifetime. What it's going to do, though, it's going to speed up the administration of your estate and avoid the cost of probate. Also, the revocable trust then becomes really your dispositive document. It will have all the provisions in there about what will happen to your assets after your death. And keep in mind, you could have a beneficiary who's got special needs and you want to protect the government assistance for that individual. So you want to set up a special needs trust. You also may want to set up trusts for certain beneficiaries to protect the assets for maybe a creditor or a divorcing spouse, and even put assets into a trust to protect against any elder financial abuse. So trust can be used basically to avoid probate. So other documents that you should have are powers of attorney. And there's basically two types of powers of attorney: financial and medical. With a financial power of attorney, you provide the agent what they can do on your behalf should you become incapacitated during your lifetime. So basically, they step into your shoes and can make financial decisions on your behalf. And once again, you should have a primary agent and then a successor agent named in that document. The medical power of attorney basically allows the agent to make medical decisions on your behalf should you be unable to. And once again, you should have named both a primary and then a successor agent. Keep in mind that once you die, both of these types of powers of attorney are no longer in effect, and those agents cannot act on behalf of your estate. Other documents that you should consider having: I mentioned that Wisconsin is a community property state. We call it marital property here in Wisconsin. And what that means is that any property that's classified as marital property means that each spouse has a 50% interest in each piece of property classified as marital property. And there's some income tax advantages to property being classified as marital property, in that both halves get a step up in basis to the date of death value, even though only one half is included in the estate. Keep in mind that even though property may be classified as marital property, title still determines who manages and controls that property during lifetime. Other documents that you may consider having are HIPAA waivers. Basically, that says who medical personnel like doctors, hospitals, nurses, etc., can release medical information to while you're alive. And you can have multiple people named on that waiver. The other document would be a living will. Now, in the United States, only 25% of Americans have a living will. And what a living will deals with is end-of-life decisions. So let's say you're in a vegetative state, and this document will then set forth what you want to have done if you're in such a state. You know, what procedures, what processes do you want to have in place to continue you, or do you just want to have someone be able to pull the plug? So those are the types of documents you should consider having. And now I'm going to turn it back to Rick to talk briefly about some estate planning strategies.
Thanks, E.G. So when we think about those documents that E.G. just went over, the drafting of those documents can incorporate different types of plans and different levels of sophisticated provisions. Three very general categories of planning involve these that I've brought up here on this slide. And let's think about these in terms of a couple. So one, the most simplest, an outright bequest plan, which is where whoever is passing is going to leave everything to one or more people or organizations. Simple, but you don't have control on the management of those assets after you pass. It just goes outright to those folks. Another type of planning category is what's called a disclaimer plan. This allows for flexibility by whomever your heir is, assuming it's a spouse. At the time of the first spouse's passing, everything goes to the surviving spouse, but they have the ability to disclaim all or part of the inheritance, perhaps into a trust that ultimately might go to children or grandchildren or further descendants. The ability of, or the potential to use a disclaimer plan allows additional flexibility, but also there really isn't any control on the spouse passing because it's all up to the surviving spouse to make that planning decision on how much should, if any, be disclaimed. And then you've got what's called a credit shelter trust and marital share plan, where in the very simplest terms, and we'll see a diagram on the next slide, you leave everything to the extent of your remaining lifetime exemption to a trust. Let's call it a credit shelter trust. Anything over and above that funds the marital share, right? And your surviving spouse has access to essentially the trust income and the marital share assets. But in the end, once the surviving spouse passes, let's even look at that diagram, Jennifer. We can see that the assets ultimately end up, assuming there are children, and those are our heirs, to the heirs. So if we look at the top, the descendants' assets, upper left, go to the credit shelter trust, which is the applicable exclusion amount. Anything over and above that goes to the marital share. Now the second spouse passes, everything is joined back together, essentially for the children. Very simple, very general, but yet this particular plan provides some asset protection for management of assets so that they will stay in place until they reach our children. It allows for your goals and wishes in terms of how the assets should be distributed to stay in place. So while not simple, it allows for additional flexibility. Now, when we're doing this type of planning, we have one or more of these planning categories that we're utilizing. Let's think about those that have this level of wealth that rises into the estate tax paradigm. A couple of different or two different mechanisms that we as practitioners will often use to help people save estate taxes: discounting and effective grantor trusts. I'm not going to spend the time, because we don't have it today, to go in depth, but these are very important for a number of reasons. Discounting allows you to value your assets at the lowest value that you can. So let's say we have minority because we own less than 50% of an asset, or we have marketability because there's some restrictions on liquidity of a particular asset. And we can value those assets less than what we may be able to convert them to. If I own something worth $1 million, but it has a marketability or minority discount of 30%, now it's $700,000. Why is that important? Because I can either gift or leave at death $700,000 of something that potentially could end up being worth $1 million. That discounting is helpful when we try and eliminate or reduce some of someone's estate tax. Utilizing grantor trusts can be important and impactful because it allows you to place through gift or sale into trust these particular types of assets and then freeze that value so that the future appreciation also is outside of your estate. The reason I want to bring these up in today's talk, is that the House Ways and Means Committee that I referred to earlier as drafting the budget also wants to eliminate at least part of these types of planning techniques. And so again, the urgency is now to think about doing gifting and planning if in fact you are in this type of estate tax situation, so that we can utilize these techniques before they become unusable. So what are some things that you could be doing now? Again, we talked about what you should be gathering and thinking about in terms of questions. We actually have on our website an SVA workbook that will help you put some of these thoughts together. And starting with that, is some self-help you can do in advance of sitting down with your advisors. Really, these are things that once you've created these lists and sat down with your advisors, don't forget to talk to your family about what your plans are, because if they don't know, it's very traumatic for remaining family when someone passes, and in how they are to respect one's wishes, as well as the medical powers that, for instance, that E.G. talked about. If you don't sit down with your family and talk through what desires you have and how you should be helped to make decisions in terms of medical situations, if you don't sit down and communicate with your family, you may not have all your wishes taken care of. So let's, for the most part, end today's webinar with a final polling question, which is, have you discussed your intentions with your heirs in any way, shape, or form? Simple answer is yes or no. %, which is way more than we usually find out, have discussed their intentions with their heirs. And I applaud you for that, because one of the things that I find, which is the second fatal flaw of estate planning, is not only not having a plan or having it in writing, but not having communicated it to the next generation. So I'm glad that you have. Now let's, for those of you that have communicated it and don't have it in writing, let's get it in writing. So in conclusion, your next step should be talking to your contact person at SVA. And as pointed out, after you think you've finished completing your planning, communicating it with your beneficiaries. I really want to thank you, and I hope this has been educational. We are here at SVA to help you in any way we can. And I will turn it over or back to Lee to close this up for today.
Great, Rick and E.G. So much information. I know we're already a minute past the half hour. However, we did have some questions come in, so I want to give you guys a chance to answer a couple of these. So hang on if you can. So we've had a couple of similar questions come in. I'm going to ask both of them. I think there's really one answer. One said, I'm not anywhere near the estate tax limits. Do I still need an estate plan? We've kind of already answered that, but we also had a question. Married 35-year-old with 3 kids less than 5. Do you think it's more important to take extra time for officially drafted legal documents or to expedite sharing your plans in layperson language with friends and family to avoid ambiguity?
Well, I think, go ahead, E.G.
Well, I would just have an attorney prepare the necessary documents, and then you can supplement those documents with your friends and family by explaining that in the layperson terms what your wishes are as to your assets and guardians for your children. So I would do both, but I think I would have a lawyer draft them. That's the more important thing there.
Right, because without official documents, you don't have what would be considered the nuts and bolts to make your wishes happen and to get the things that you have to whoever you want them to go to. And when you don't, the laws of intestacy, the statutes of a state and a probate court will make those determinations.
It sounds like one of the real takeaways, guys, is it doesn't matter how much money you have, you need to have this in writing.
That's correct.
Yeah. Okay, so another question that came through was, how do you suggest bringing up these topics with your parents or family members? So I think this person's coming at it from the perspective of, how do I make sure as a potential heir that, you know, people I might inherit from are communicating this to me?
Right.
Sounds, could be tricky.
Family dynamics are different across families. Of course they are. But that said, best practice for family would be to have these open discussions, and that you as a potential heir hopefully would have been communicated to by the senior generation. But if you weren't, what you should ask is that you go to a parent, let's say, and say you're putting your own estate plan together. You want to make sure that you're responsible and acting as a good steward for family, any family monies. And to that point, if there are any inheritance, which you don't necessarily expect, that you would be able to provide for them. And hopefully that type of communication would draw out the parent. And oftentimes what I'll see, depending upon how old the parents are, is that there's this paradigm where we don't like to talk to our children about money. And that's fine if that's how you feel. Look, you're going to make your own decisions about money. But that said, as an heir, to ask that question, it's not out of line. And if you ask it respectfully in a way that says that you're trying to be a good steward, hopefully the parent will open up.
Great. All right. Well, knowing that we're already a few minutes past here, let's wrap it up. If you do have additional questions, feel free to reach out to us. And I just want to let you know, Bonnie just posted it in the chat box, but we do have a resource page, which is svaccountants.com/eguides. where the workbooks on trust and estate planning, in addition to a whole host of other topics, are available. Coming up, we have a 3-part exit planning strategy series, as well as some industry-specific events for veterinarians and for dentists. So please check out our events page as well, if any of those are of interest. And I just want to remind you all that the SVA team is only a phone call or an email away. So if you're a client, please reach out to your SVA professional as questions arise. And if you're not currently an SVA client, or if you know someone that would like to have a conversation with us, just contact me, Lee Schwartz, so I can get you the help or the answers that you need. Thank you all again for joining us today, and please have a great rest of your day. Bye-bye.